Okay, so you can hear me. This is fourth week, so my intention is to expedite our coverage. In this class, we'll get some further about the case briefing. What actually might be disrupted by background noise. So we are now in feast year. Okay, nighttime, often disturbed by noise and music sounds. Your entertainment is quite consequential to impose some difficulties about class performance. But I'm sure the noise could be insulated since and also context. So the previous class has the case briefing. So I introduced some what a state case, quite brief, from New York State. What actually parrot is so exciting animal, kind of bird, to what the same with human. They what actually mimic exactly what is said. They need trained and domesticated to be devoted to educational activation, and the owner has lost the property, and a reprimand action has been filed with court. The law very interesting, as I've introduced. So the lost property from the ancient Roman law has to be restored to the owner. That is the rule of law, always through upheld by common law court. They have distinct ties between animals and objects. The animals would not be same in their perception, and any legal intelligence consider there is a wild animal which should be treated different in legal terms. Once they leave from the possession of a owner, then the property ownership will cease at that point, and the bird, for example, could amenable to new ownership. So who actually retrieve the birds or their food to might be provided, and the bird might be accepted. But accepted the food for his subsistence. So then a new ownership could be created as a matter of law. That would not be same with domesticated or trained bird. You see, in that case, the trained animal would be kind of a object we expect in reprimand action. So still should be reverted to the original owner. So that is typical, often illustrated to describe the trait of common law. So you will have that case typically in the fourth class of property law and others. You would be curious if you're a civil law lawyers, since we often are trained within statutory dealings. So the general abstract nature provision would provide the legal principle in the first place, and the court would be an authority to interpret the laws and recognize the laws and conform its legal effect and apply to the specific case he is responsible for. So the deductive reasoning would be often avenue to structure their thought and deals with his responsibility. So inductive reasoning, in contrast, often pursued by common lawyers to express their opinion, and the rules of law could be created in that process. So what a narrow-z and kind of a comparative work to distinguish the case would be principle as routine responsibility for the common law judges. So in this week we will learn some important skills about lawyering in some sense, and what you might know the pro bono program, for example, for the law students and many writing class to increase competence in legal writing. And one other important class would be to the concern of your case briefing. So how effectively prepare case briefing. So I presented two forms of case briefing. For example, you will need to prepare an appellate brief. You will lose the case in the trial court, and you decided to appeal the judgment of lower court. Then perhaps you have to deliberate how to structure your argument to appeal, to persuade the judges of appellate court. So your task is now on the challenge, how to increase your power persuasion or other a legal viewpoint to overrule the lower court judgment. One other context would be student brief. Law students would be asked to brief case by the professor. What is the fact? The Socratic method is notorious, as you know, in the legal education of the United States. So they exchange their ideas, and the fact pattern is often determinative in creating a case law that is very basis for the new product. So the case law, the court opinion now delivered by this court would be a new law in the conception, as I stress always, all the way through this class. So that is the aspect that we now consider to characterize the common law legal system. So they recognize the court opinion as law. So institutional insulation and their independence is very dispositive which now allows different evolution between two major legal traditions. In the continental system, as I've said, the will of political branches would be unique source to create this statute and public decrees from the executive, as I earlier illustrated. You will see basically no differences between two types of a case brief, a appellate brief, a student brief. You may well imagine, however, the appellate brief would be unilateral in their tone and argument, since they represent one party and they now work to protect the rights and interests of the client. So they have to employ the viewpoint to support the position of defendant. That would not be the case for the student law brief, case brief, since the principal objective of a student brief, case brief, would be to prepare for classes and might construct some basis of study materials to increase his understanding of laws delivered by professionals. So the student brief would often be concise and neutral and objective, and often mirror the case court opinion in much extent. Right? So the appellate brief would include nonetheless some insight and suggestion to criticize the fault of a lower court judgment, and the kind of creativity and what reality would be important variant or the distinct from a student brief. Nonetheless, it would be wise to grasp both in same form generally. So the importance in case briefing would come in one point, so that you need to be consistent about the use of terms and jargons. And as I've said, the words often, or the terms employed in case briefing work would be not familiar for laypersons. Plaintiff, for example, what is it? We do not use that word routinely, so not common words, perhaps a jargon for the law professionals. What is defendant? What is appeal? And what is respondent? What is petitioner? And many words. Actually, I have once illustrate the historical backdrop about common law system. So the conquest of Duke William, actually the beginning of Western civilization, especially for legal system. So new conqueror imposed the feudal system in Old England. So before the conquest, they used Old English, and local court would serve a piecemeal of justice, which is quite actually local, and also not nationalized in many senses and in practical effect. So you may imagine some primitive form of a feudal system. No central power was effective in before conquest Duke William, and that situation changed. So now the conqueror from French land would impose new feudal system, and his ambition is to nationalize the New England, and the common law code is the principal instrumentality to serve his power monarch. So, what is the word mean? Meaning, common law. Common means could be powerful through the nations. Now, local variety could not made extent. The rule made by one code has to be coherent to be enforced through all the system of code in the nation. So we say a common. Of course, you will see the early institution of Court of Exchequer, for example, which was created to subsidize the funds of a purse of a monarch, and other court system would be distinct. Nonetheless, it is important that the conquest could centralize the judicial system in the United States. That is the point, epochal, to make the common law system evolutionary over centuries and others. So the official language in the new common law code was French. So many French terms have influenced the legal system in the United States until through the 18th century or others. So now the terms and jargons used in case briefing would often of a French origin. So those and in the next class I have illustrated some more. So case briefing need to be consistent and brief, but should illustrate all the elements of case to be noted. So you may perhaps be made expedient with the headings being attached. For example, what is that? You will start with a title and citation. So the case name and citation would appear in the first part of the case brief, and facts section would appear, which should be brief and must incorporate all the essentials significant in legal consequence. So that's the basis, as I've listed, to create the rules of law. So it could be lengthier in some cases, but shorter in other cases. But the importance is to include all the facts relevant actually basing the court decision to reach some kind of conclusion. For example, why the court reached this conclusion, why they announced the rules of law in this legal term. What often the court opinion would correspond with legal issues practiced by lawyers and what they disclosed in the process of court argument, and so the issues would entail largely the specific court opinion. So paragraph to paragraph court opinion would be encountered in cases, but I'm not sure it would be common, perhaps in contrary. So in domestic court practice, you'll see that type of presentation is very seldom. That is in contrast with what a practice of international courts. For example, you will have paragraph to paragraph rulings from WTO panel opinion or APA or appellate judges, appellate court in WTO. Nonetheless, I consider it would be straightforward in some sense, and might on highlight to focus the issue, and also would work not to miss the important points of contention or issues raised by a party. In that case, it would be easier in your case brief work. In other case, you have some standard to delineate the facts to be included in your case brief. So have an insight, and one way would be to juxtapose the facts with the issues and court opinions which appear later in section. And one other strategy also is working in my experience that the facts from separate opinion would show in most instances the point of contention is often centered by both parties. The parties would be adversary, and they comprehend the facts in a different perspective and viewpoint. So the dissenting opinion or concurring opinion in other cases would present the case, the facts in other perspectives. So the explication would differ, although the facts reached by court is same based on the evidence. So the evidence is concluded to state the facts in any concrete language. So it appears in as a majority opinion, so often called court opinion. And we state other term, separate opinion, to cover types of opinions from each justice who concur but on different footing or legal reasoning, or dissenting opinion stated briefly dissent would expose a disagreement on the final conclusion of court. So that would be in practice in the domestic court of the United States, and the system also was implemented in Korea. So you see a provision in Civil Procedure Act of Korea about filing a separate opinion. So it is a legal requirement demanded by statute. So it would be unlawful to but exclude the separate opinion in the court document. So as a matter of law, it is required. And also that practice is now in ICJ, International Court of Justice, and perhaps in WTO appellate body. So that is necessary to record plurality of a legal viewpoint. So the opinion of a court, especially the Supreme Court opinion, actually foundational in terms of a public governance and what a democratic structure of government, often critically intact with judicial branch, especially when they practice the system of constitutional review, and so that is very significant to be on record for public access or future reference. So and also shielded the democratic interaction in the forum itself. 9 justices are working on democratic value. So the majority opinion of one justice could not be rendered disregarded in that sense. Then what is coming next in case briefing? Well, so your imagination is correct. So the issues, and often you are heard of the importance of issue parting skills in the law school curriculum. So the workers' skills, talents, expertise often is related with the issues parting. The skilled lawyers have some a standard, and actually a quite important achievement you could have made it possible through the law classes. Of course, you have to read many cases possible to increase the skill, issues pattern. So in this pattern, the kind of issues often arise in these points, or in this frame, or you have basics. In terms of case briefing, you will see no difficulty generally, since the issues would often be summarized earlier in court opinion by the court. So you have no fear in that context. And the legal court holding should appear in next section, and also legal reasoning will follow. And that is an important point in case research. So the view or logic and metaphor would be available, which is not necessarily out of a legal consequence often. Actually, the court rulings is source of law, So the rules of law could crystallize as a law, and the legal reasoning will support, and you'll find the delicacies when you work on distinguishing or work marriage among cases and others. So it is the basis for your interpretive work of a precedence. So you should be prudent to read the court reasoning, and has to sift and winnow the court words and phrases. Why what the reason, for example, why the court stressed this point in this metaphor. What is the logic, basically? So you imagine as many hypotheticals if you are a brilliant student. So compare the case, hypotheticals with the case at hand, and consider the rules of law now challenged by the case you're now working on. Imagine, for example, we'll have this rule about dangerous electronic saw, which is used to cut timber wires. The electronic saw is an exciting product of invention to accelerate the industries in interest. For example, timber industry would be adapted to that development. You might know. I consider the case about this electronic saw is what actually the basis to create the rules of product liability. So ultra hazardous activity, many new rules or principles could emanate from this case law. Then you will expand your hypothetical situation about many other products which is dangerous or incurs ultra hazardous activity. So the traditional rule about fault in torts could be or modified or change it to be adaptable with new situations and technological advancement. So the wisdom of judging a specific case is the basis. You develop some general theory of law, actually. So inductive reasoning would be illustrated in this kind of interaction. So the case grouping will be dealt in further extent in next class, and in this class I would present the basics of court system in the common law or legal tradition. So you will see in projection several titles: stare decisis, courts of equity, the state court system, the federal court system, constitution, and bill of rights. So actually our purpose is to increase your familiarity and exposure in basics to the common law system, and the legal research would complement with this class purpose. So let's begin. For example, a traditional important is state decisis. It is a central concept, perhaps, in your understanding of American legal system. The practice of deciding new cases with reference to former decisions or precedents eventually became a cornerstone of the English and American judicial systems. It forms a doctrine called a stare decisis, the doctrine of precedent. What does it mean in English? To stand on decided cases. The doctrine of stare decisis suggests the judge attempt to follow precedents. The doctrine helps the court to be more efficient, because if other courts have carefully reasoned through a similar case, the opinions can serve as guides. Stare decisis reflects the experience, wisdom of the past. The doctrine also makes the law more stable and predictable. So you often instructed with such important ideas in legal system. One is stability and predictability, and you will perhaps be stressed by a professor in the first class of civil law, and you will locate some web page from WTO, for example. What's the regime? Trade, International Trade Administration. Actually, the organizational purpose is to increase stability and predictability in international trade. So the rule of law administer international trade laws is the structure they sought to regulate commerce in legal ways. So it is the idea of laws and legal system, basically. So suppose if this doctrine would be a derogatory, then you will see what chaos about legal relationships. The due expectations would be frustrated. So what is that? For example, we now experience some pension reform about public government employees. Actually, the fiscal crisis is very related with that context. So the government might have no avenue to avoid that reform. A good solution could not be reached without any reform. Nonetheless, the reform could not be made bluntly against the stable and retired officers. They could not enact a retroactive act as a matter of law and as the value of a liberal constitution. So that would be one case. You could exercise your topic in relation with stability and predictability. Nonetheless, it could be reformed from the consensus of interest parties. For example, the employees recruited since 2016 could be applicable and fall within the scope now the government now works on. And stare decisis is an English principle which actually embedded in common law system. Then what is a pure concept in continental civil law or legal traditions? Stare decisis doctrine would not be embraced as a matter of theory. I'm not sure if it could be on practical effects. So we now, the civil law lawyers often enchant the court cases, especially the cases from Supreme Court, as precious and actually impacting to resolve the controversies at hand. Nonetheless, as a matter of law, it did not bind the judges or lawyers, so they do not respect, as a matter of theory, the stare decisis doctrine. However, we have some concepts similar, for example, vested rights and a constitutional shield, for example, contract clause in the United States and other legal apparatus would operate to ensure stability and predictability in terms of a property right and contract law. The government could not intervene in the contractual relationship. They could not impose conditions which is required publicly, for example. What is the concept vested right in terms of administrative law? So that also is an aspect in the legislation or pension reform of public employees. So the consequence could not be in fair difference between two major legal traditions, I suppose. And as a matter of theory, it could come in a spirit and a disagreement, or new law always alter the previous legal relationships as a matter of theory. For example, the doctrine later in time law would prevail, for example. So the statute scheme could extend that context of interaction deals. However, we have some constitutional or countervailing institution from the Constitution, as I've illustrated. So consider comparatively the dynamism between indifference between two legal traditions as a matter of theory, and the similarities in practical effect between two major legal traditions. The rule of precedent tends to neutralize the prejudices of individual judges, and if the law on a given subject is well settled, someone bringing a case to court can usually rely on the court to make a decision based on what the law has been. Sometimes the court will depart from the rule of precedent if it decides that a given precedent should no longer be followed. And if a court decides the precedent is simply incorrect, or that technological or social changes have rendered the precedent inapplicable, the court might rule contrary to the precedent. So basically, this statement would largely be true. The principal responsibility of common law judges would be to interpret precedent cases decided by previous court. The basic responsibility of civil law judges would be interpret the statute, constitutional provision on the basis. Of course, they will refer respectively the precedents of former or previous code orders. Nonetheless, the formality and structure in process will differ in that point. In these situations, a court is guided in its decisions by fairness, public policy, and legal reasoning. Cases that overturn precedent often receive a great deal of publicity. In Brown vs. Board of Education, for example, the United States Supreme Court expressly overturned precedent when it concluded separate educational facilities for whites and blacks, which had been upheld as constitutional in numerous previous cases, were inherently unequal. So, this case is epochal in the area of equal protection laws. One illustration, quite striking, to understand the state decisis rule. So, the separate but equal rule, upheld traditionally through the century, has been abandoned. So, new policy change is quite demanding to adapt with evolution of environments. So now the segregation in basic classification deemed required, deemed invalid. Desegregation would be more proper to fit within the commandment of equal protection of laws, 14th Amendment. Courts have other sources besides precedent and common law to consider when making their decisions. These include federal and state constitution, statute law, administrative agency regulations, and common law codes. And in this ambit, the post constitutions and statute law regulations, the kind of expression of political branches, would prevail the specific case law. So the consequence would be shared between two major traditions. The point is that they would often be reluctant to enact a statute about traditional area of a common law. So they do not have many statutes about tort theory. For example, liquor shop statute would be one example, however, to respond with juvenile misdemeanor drinking practice or the increase of traffic accident. So the aggregation would be serious if the legislature, Congress would determine to enact some special tort law. So they, of course, they would have no basic civil codes, unlike South Korea, Germany, Japan. The public law would be similar in volumes or the ways of dealing in this concern. So the United States has filed of a public statute about public governance administration. And the code would actually then have need to reflect both sources of law. So they would investigate if the statute and case law would in conflict with others. They might have some restrictive view against lesser viewpoint. So the case law from this process of interaction would also be a case law, new case law, which now is created in hybrid deliberation between statute and case laws. And so they have two sources to be interpreted in crafting new laws in their responsibility. And you now move on to courts of equity. I suppose you might be familiar with this term, and heard of other classes, and the two branches of court system in British heritage, and the vestige now be discerned as in remnants in the American legal system. Equity is the branch of unwritten law, founded in justice and fair dealing. The seeks to supply a more equitable and adequate remedy than any available remedy in law. So the concept is in contrast with common law code, two branches of code in the common law system. Court of equity is responsible to ensure fundamental justice. So they would often be freed from technicalities of common law. The common law code should be leery of jumbles of case laws. So they have to head on, or a sea of case laws, and the case law could be on impasse, but to apply some awkward rules since it is structured in coherent fashion. They have no other way to contravene the dictation of previous cases. So they would be futile, or in some cases frustrated about fundamental justice. In that case, the court of equity would be an effective system. Often actually supervening in the name of Queen, for example, into restoration of basic justice. Basic humanity or communal value could be pronounced beyond actually transcending the difficult case laws. When individuals could not obtain an adequate remedy in a court of law because of strict technicalities, they petitioned the king for relief. Most of these petitions were decided by an advisor to the king, called the chancellor. So you will hear in the world history class, so very familiar with this word, I suppose, chancellor of law, still official title to denote the important judicial rank in Great Britain. Perhaps comparable with Chief Justice of Supreme Court in other countries, Privy Council or Lord of House of Lords. The Chancellor was said to be the keeper of the king's conscience. Many fames in the judicial discourse or legal philosophy class would have this title, the Chancellor of Law, perhaps Sir Blackstone, Edmund Coke, and others, brilliant common law theorists, now recall to support your intelligence, has this official title. When the Chancellor saw that the claim was a fair one, new and unique remedies were granted. In this way, a new body of Chancery rules and reliefs came into being, and eventually formal Chancery courts were established. These became known as courts of equity, granting remedies in equity. Thus, two distinct systems were created, each having a different set of judges. Two bodies of rules and remedies exist at the same time, remedies at law and remedies in equity. So these terms will also be frequented across your case books, and remedies at law, remedies in equity. Some exotic rule might often be related to remedies in equity. Plaintiffs had to specify whether they were bringing an action, a law, or an action in equity, and they chose their courts accordingly. For example, a plaintiff might ask a court of equity to order a defendant to perform within the terms of contract. So the contract, terms, plaintiff, equity often has French origin in linguistic history. The court of law could not issue such an order because its remedies were limited to payment of money or property as compensation for justice. A court of equity, however, could issue a decree of specific performance in order to perform what was promised. So you will hear of this rule, a specific performance about contract, breach of contract. So there are normally three types of remedies in a case of breach of contract: specific performance, damages, and a revocation of contract. Specific performance has a root basis on the course of equity and the distinct preserve of rules. A specific performance is a primary tools for the civil law countries. Contractual damages would be contrary. So contractual damages is first place in terms of a breach of contract for the case of common law countries. Likewise, a court of equity could issue an injunction directing that the party refrain from engaging in a particular act. So the institution of injunction is also bearing historically as a root from this court of equity. It is remedies in equity, not remedies alone. In certain cases, when the legal remedy of the payment of money for damages was unavailable or inadequate, the court of equity might have allowed for the rescission of contract, that is, the undoing of the agreement, to return the parties to the positions that they held prior to the contract formation. So this is a type of radical remedy. So what actually overhaul all the existing relationship between parties. So very is forcible in nature, and actually has a root basis in court of equity. And in the next title, you see state court system. Consider the typical state court system. It has three main tiers: state trial courts of general or limited jurisdiction, state appellate courts, and the state supreme court. It is true that most states have three lengths of a state courts and have same title in denomination, sorry, to indicate the specific code. Nonetheless, you have a different name in cases. For example, in New York State, the New York Supreme Court will not actually be a Supreme Court. The Superior Court in New York would be Supreme. So the nomenclature differs actually in that case. So you need to be considerate about understanding state court system. What is this? I have illustrated one in context of Florida State in last class. So Federal District Court of District Court of Appeal in Florida. What is that? District denotes often the federal court, and also the indication is friendly with a trial court district. Nonetheless, it is Court of Appeal in the state of New York, state appellate court actually. So be considerate. The trial courts have either general or limited jurisdiction. Trial courts that have general jurisdiction as to subject matter may be called county, district, superior, or circuit courts. The jurisdiction of these courts of general and original jurisdiction is often determined by the size of the county in which the court sits. Courts with limited jurisdiction as to subject matter are often called special inferior trial courts or minor judicial courts. Small claims courts are inferior trial courts that hear only civil cases involving claims of less than a certain amount, usually $5,000. And you will have one name in this context, a federal claims court. It is district court and constitutes as one of a 13 federal district courts. And what is that is? Out of outside the in terms of jurisdiction, international trade court, a court of international trade, and the dual dimension in sovereignty about practice of U.S. constitutionalism is also related with legal research. So you have standard to make it yourself accelerated between the state and federal court system when you conduct legal research. So facile to retrieve the state cases now in the search of a reference, and you have to work effectively on the federal cases. And you will have another concept between two legal systems, federal common law. It is actually an evolutionary concept which varies with traditional scheme of civil procedure, for example. So the federal common law claim could be established as a matter of law in some restrictive area. Often the common law is based on state. So the federal common law is intertwined with kind of federalism in the United States, as the world knows, as per Plato. Most small claims are less than $500. Suits brought in small claims courts are generally conducted informally, and lawyers are not required. So it is same with Korea. So we have a small claims courts, and some distinguished institution is open to public access. So you have no need to purchase by your lawyers in claiming your right, which albeit is a small amount. Well, $500. What is the amount in Korean case? Decisions of small claim courts must maybe appeal to a state trial court of general jurisdiction. Other courts of limited jurisdiction are domestic relations courts, which handle only divorce actions and child custody cases. Local municipal courts, which mainly handle traffic cases, and probate courts, which handle the administration of wills and estate settlement problems. So could be expanded in terms of jurisdictional question about subject matter. So domestic relations courts. Do we have probate courts? I'm not sure it is instituted as a matter of a system or any. That is probably because the laws of wills and estate, the structure of theory embedded historically through the common laws would differ. So fees, simple, for example, fee defeasible. So what the kind of very challenging theories, which what actually often provokes chaos for the first-year law students with the law property in the United States. And it would be striking, for example, if they find a simple system about public registry or recordation system of a ownership rights, others in civil law countries. Of course, they have some system about public record in ownership or others. In any case, probate courts might be distinct in the common law state court system. In some states, trial courts of general jurisdiction also have limited jurisdiction to hear appeals from the minor judiciary, for example, small claims and traffic cases. Every state has at least one court of appeals or reviewing court. The subject matter jurisdiction of these courts is substantially limited to hearing appeals. These intermediate appellate or review courts are often called courts of appeals. The highest appellate court of the state is usually called the Supreme Court. They examine the record of case on appeal and determine whether the trial court committed an error. They look at questions of law and procedure, but usually not at questions of fact. So this is one concept you need to make a point of. Questions of law, questions of fact. The concept not be independent, unique for the common law system. It matters in some area of legal theory to affect the civil law countries as well. So, for example, the questions of law should be investigated ex officio by court. So the court have to find the proper law to be applicable to the facts concluded based on the evidence. That's the responsibility of court. That could differ when you see questions of fact. Questions of fact could not be claimed by court. So it falls within the responsibility of parties, which should often, generally adversary between plaintiffs and defendants. So the court, as a matter of law, could not deal with the facts not raised by parties. The party autonomy, in the civil procedure would also take an effect in the procedural issue when we discuss civil procedural act. And the concept, therefore, is universal between questions of law and questions of fact. And also, important element you have an awareness when you consider the conflict of law issues, or for example, international dispute of private nature. So in that case, the foreign law could be dubious in status or distinction between law and fact. In some thought, the foreign law would be fact. In other perspective, the foreign law is still law. Often they would be considered fact. So the court handling the international disputes would not be responsible to find foreign law ex officio. So they can legally be dependent on the argument or claims raised by parties. The decisions of each state's highest court on all questions of state law are final. If a federal statute or constitutional issue is involved in the decision of the state Supreme Court, the decision may be further appealed to the United States Supreme Court. So three types of appeal system often is imposed by many countries in judicial practice. The United States is typical in this context, since four types of review system could actually be in reality. So, for example, you will hear of the institution, certiorari. It is the legal instrumentality used by United States Supreme Court about important human right questions or constitutional issues. So actually, the Supreme Court of the United States suffers from top case laws. So the Supreme Court justices' responsibility is quite in extended scope. For example, they would be geographically responsive among 9 justices. You are now responsible to Midwest region, for example, the Southwest region, and they hold judicial conference in regular basis of session about important public issues or judicial policy, for example, and they have to handle the cases appealed by respective states. So what actually imposing in challenges of case law concern. So they use a certiorari. So they practice a very selective review when they decide it's important and must be clarified in the interest of a U.S. legal system. Then they, the appealing party may be granted to appeal to the United States Supreme Court. So in that case, we'll have 4 types of review. And the United States Supreme Court actually is federal institution, and the scope is limited as a matter of constitution about federal issue or kind of so we have two institutions in terms of a power of United States Supreme Court. So original jurisdiction, appellate jurisdiction, you will have basics about that structure to the point, and so that could make the United States common law system unique in that sense. Of course, in other instances, you find that aspect of this. So, for example, a private counsel would be responsible to review this appeal of a Supreme Court judgment in the Commonwealth nations. So in that case, the private counsel would be empowered to review. So full type of review has to be undertaken. And what else? How about German constitutional code? Actually, Germany has several of Supreme Courts assigned in response with a subject issues, or labor code, social welfare code, what others? A six orders. And this constitutional code is considered paramount to be competent about jurisdictional exercise. So the constitutional code may have chance to review the appeal from the Supreme Labor Court. In that case, 4 times of review might be necessary. So please search for other cases which diversion from the traditional strict type of appeal system. Okay. Sorry to neglect. Time is up, and we'll see in next class. I have to explain my progress. Okay.